Black.
Michael Act. Excuse me, Mr.
That's okay.
Apparently, I guess someone is going to be filing a motion for you to be here pro hoc vice.
That's correct.
And when do you expect that to occur, sir?
Hopefully within the week.
Okay. I don't believe under our present rules that you can appear here and speak on behalf of your client without being admitted pro hoc vice.
I fully recognize that and understand that. That's why I'm just going to listen in. I know that I've had some discussions with Mr. Blatt and Mr. Houston, so they know our position.
Okay.
And I'll just sit back and listen.
Okay. And I also know that there's a proposed order 8762, which would appoint a hearing examiner. I can't remember which one. Mr.
Yes.
Hay.
Your
Hearing
Honor,
examiner Hay.
yes, it would
Campbell Hay?
a hearing examiner.
Okay.
Art Campbell Hay.
Okay. Given the situation that one party expects to file a pro hoc vice within the week, and apparently, Mr. Houston?
Yes, Your
And
Honor.
Mr. Blatt, you all have some objections to the opening of the application?
No, I do not.
Okay, you do not.
I'm sorry.
Okay. So,
Mr. Chairman, there is an issue regarding the timing. This is Joseph Houston. There's an issue regarding the timing of the proceedings. The two principal parties believe that it would be appropriate to extend the statutory period for hearing to permit a record to be developed by an additional 90 days. Counsel to the staff has taken the position that the statute does not permit that it requires the commission to act within 90 days, or the case goes to the Superior Court. We have a different view, and I would defer to Mr. Platt to actually stake out our position on that. But in terms of opening the docket, there is no objection to that.
Mr. Blatt, comments with respect to the language which says within 90 days of the protest, then the matter shall, with the word shall, be heard and determined by the Superior Court. And I guess the issue then would be if there's no official protest today, I guess the 90 days wouldn't start to run. So I assume you're not protesting today, or is there an issue further than that I haven't? Ms. Donahue.
Yeah, actually, staff's position is that the protest is complete, although it was sort of filed out of order, given that the initial notice did not meet the minimum filing requirements and did not include all of the hearing exhibits. However, that was corrected on June 26th. The protest was complete as is, and is still complete in staff's opinion. And so we believe that protest triggers the 90 days to start.
So has the protest, is it necessary for the protest to be admitted into evidence, or is it just necessary for it to be filed in order to be part of the record for consideration by the hearing examiner or for the statute? The point I'm trying to make is that, yes, I know it's been filed as a protest, but wouldn't that have to be maybe perhaps admitted as evidence before it could be heard and considered by the commission, and therefore might it not impact upon the 90 days? That's just a question.
Do you want to ask your counsel that question, or do you want to hear staff's arguments?
I'd like to hear what staff has to say first, and I also like to hear from Mr. Blatt second, and then we'll...
Sure.
Got it. So your question is whether or not it has to be admitted into the record in order to start the 90 days?
Correct.
If I look at the statute and the wording itself in Title VI of 4915, subparagraph E, the final determination is within 90 days after a protest is filed. There's nothing about being admitted into the record. It's just the timing of the final decision made by the commission. And that 90 days starts as soon as a protest is filed. There's no wording about how the notice has to be filed before or after the protest. And there are other code sections, specifically in Title 26, that allow the parties to extend the time, but that's not the case in this particular statute. In addition to that, the regulations contemplate that the hearing be held within 90 days, and they even prepare for that by requiring the parties who file the notice to include all of their evidence in the initial notice filing. And they have a complete filing as of June 26. If the commission were to find that there was a technicality in the timing of the protest, then the parties would simply refile the protest and they would have an additional 90 days from that date. But the protest as is complete at this time. And staff's position is that the time has started. This particular order, besides appointing a hearing examiner, also has another important feature. It tells the manufacturer that they cannot go forward with inserting a new dealership in the relevant market area of the existing franchise. And that's an important component in this. If we hold off on that, the notice said that the dealership intended to set up as of the end of June. A date's already passed. So the commission does, staff urges, need to take action on the fact that the dealership has given you a notice saying that they intend to set up the new dealership within that franchise area already. Your order would correctly, according to the code, put them in a standstill position, would tell them don't move forward with that until there's a final determination by us. So our argument, staff's argument, is that it's filed. It doesn't need to be admitted into a hearing, admitted into the record. It's a filed document, which is of record, and the 90 days has already started. So if you have any other questions, I'm available, and so is the analyst.
What if they voluntarily withdraw their protest filing?
Well, staff's position would be that they could certainly do that, but it's sort of counter to what they might want to do as far as having an order that officially tells the dealership not to move forward.
Mr. Blatt?
Yeah, a couple of points. One, and we don't want to withdraw the protest. We believe that it's correctly filed, but we do think that the time limitation of the 90 days is waivable by the parties. We don't think that the Superior Court doesn't get involved until a party appeals the commission's ruling or the commission fails to act within 90 days and a party files an application to have the matter heard before the Superior Court de novo. So that's the jurisdictional nature of that, and the commission retains the jurisdiction to hear the matter until it's divested by a party seeking the relief in the Supreme Court. So I think the 90 days to issue a decision is waivable by the parties, especially in this instance, the party agrees. And my second point, for whatever it's worth, the commission's rules, which arguably, I understand, don't trump the statute, permit the commission, section 1.12, to prescribe different procedures where circumstances reasonably require for a specific proceeding. And also section 1.9.2 allows, with a showing of good cause, the extension of any time period prescribed by the rules. So in this instance, both parties are requesting an additional 90 days. I can tell you from the petitioner's point of view, we're going to be seeking some discovery from Chrysler as the respondent, and also we're going to need time to retain an expert to prepare a market study. And I've indicated both of these things to Mr. Michalak, and even with that, we both agreed that we're going to both need an additional 90 days to properly exchange discovery and really create a full record here in this instance.
Okay. Does the applicant have any objection to what Mr. Blatt said? Mr. Michalak?
Again, I'm in a difficult position of not being able to appear. We would, on behalf, FCA's position is that it is agreeable to a 90-day extension, but it's also FCA's position that given the fact that a statutorily compliant notice wasn't received by the commission staff until after the protest was filed, the protest was premature, and that jurisdiction of the commission is at risk at this point in time.
Mr. Blatt, wouldn't it be prudent to reschedule this matter so Mr. Michalak would be here officially as part of the team, so to speak, to address this issue?
I have no problem with that. As long, as it's within a set time, I don't want 30 days to go by and then, them being told that the 90 days is not going to be extended and it's further having eaten into my time to properly, get discovered from Chrysler.
Mr. Bernard, do you have any pony or dog in this fight?
No, we have no standing in this. It's the regulated utilities.
Ms. Mayrick, do you have any advice or counsel for the commissioners?
Brenda and I
Olivia?
talked about this before the meeting, and the only concern that we would express is just to make sure that the commission's aware that if you decide to table this for, say, until the next meeting, so if you were to decide that you're going to put this off for 2 weeks to allow the pro hoc motion to go through, the only thing that I want to make sure that you're aware of as a commission is that the stay that staff mentioned would not be in place, so that there would be nothing from the commission being sent out to the parties instructing them not to construct and start this new facility. That hasn't happened yet. So that's the only thing that Ms. Mayrack and I want to make sure you're aware of.
I would assume that this improvement is probably in the millions of dollars, and you have some concern that they're going to go forward with something like that without the permission or an order from this commission.
The statute.
I think I can sort of appease everybody's concerns. FCA Chrysler is not going to be establishing this dealership while this protest issue is pending. So, whether it's by statute or by agreement at this point in time, we're not going to be opening up a new dealership and run a risk of having it have to close and deal with the fact of the protest.
Okay.
Mr. Chair, sorry, I think I heard two different statements. The one statement they're not going to, and a document that indicates that they plan to. I'm a little confused.
Did you hear that question, Mr. Michaelot?
I did not. I'm sorry.
The question basically was that some representation has been made that they're not going to proceed, the applicant's not going to proceed with the construction or the formation of this new dealership. On the other hand, there is obviously something in writing that indicates that they're going to go forward.
Perhaps I was unclear. I mean, the intent is to proceed with the establishment of the dealership. It's not, according to the statute, once the protest is filed, going forward on that is stayed until the commission renders a decision. And that's where we are right now, is that we would effectively, do by agreement a stay that's required by the statute. But it's our intention to go forward with this.
Okay, so notwithstanding the fact that there's not going to be a written order with a stay, you're representing as a non-attorney appearing before the commission that on behalf of your, I guess it's going to be your future client in this proceeding, that they're not going to proceed with construction or any. Okay, I understand.
Yeah, I am. It's not a future client. I represent FCA. It's just a matter of my getting appointed pro hoc vice in Delaware.
Yeah, well,
so I can represent to the commission and I can represent to McGee that we will abide by the statutory stay voluntarily until we reach a resolution with regard to the protest.
Is there some way that the parties can help me with this in order to, in other words, Mr. Hay is a very competent, capable, hard-charging hearing examiner. Is there any way we can get him operational as far as this issue is concerned and yet reschedule this to the next hearing? Any ideas to help me on that?
Well,
I have two suggestions. One is the issue today, I think, that could be resolved one way or the other is whether or not the parties' agreement to a 90-day extension is acceptable or not acceptable. I mean, if it's acceptable, then we're on a slower track and we can get things done in a reasonable manner. If it's not acceptable, then we have to deal with whether or not the commission's got jurisdiction, which we probably would need to schedule as quickly as possible, or the commission can determine sua sponte whether it has jurisdiction. It seems to me that those are the most paramount issue today is whether or not the parties' agreement on the 90-day extension is acceptable.
Okay.
Right. I think Mr. Michalak is saying that he would withdraw the jurisdictional objection if the 90 days is granted.
Mr. Blatt is correct.
If given the representation that the stay will be voluntarily followed, I'm wondering if that changes the position that the protest won't be withdrawn. If there's a withdrawal of the protest, then the 90 days is not ticking and the parties can cure this for themselves. If the commission were to, say, take the position that the notice, once it was cured, on I think the 26th, starts the 30 days for the filing of a protest, then the parties themselves could extend this time a bit by allowing the 30 days to click and then filing the protest, and then the 90 days would start from there. I heard a representation earlier, though, that the parties wouldn't be willing to withdraw the protest, but I'm wondering now that we've heard that there's going to be a voluntary stay, if that changes the position.
I guess it's in your ballpark, Mr. Blatt?
Yeah, I don't have the authority during this phone call to withdraw the petition.
What if we were to reach an agreement that the protest is effective as of a certain date, rather than going through the form and substance of withdrawing and then refiling the protest?
Well,
couldn't we reach an agreement that the actual protest is effective as of a certain date?
Well, as I'm sure you're well aware, we're a body established by the legislature, and we're pretty accustomed to following what the statute says, unless there's a legal provision that would permit us to do otherwise. And I don't know that we just can't ignore, I don't think, the statutory language. I think the parties have given us some leeway, and since the protest is not going to be filed, that means, or withdrawn, that means the 90 days is running. I guess going back to my original question, which is how do we, I guess, can we engage Campbell Hay as our hearing examiner? Well, I guess the solution we have, one solution is pretty apparent, and that is just to approve the proposed order and let the chips fall where they may, given the circumstances that the commission finds itself in, not due to its circumstances, but rather the circumstances, and with no adverse influence from it that the parties have put us in, so to speak. So I think that maybe, after looking at all the different ways to go, that the best thing for us to do is probably just to open up the docket. Campbell Hay is well aware. I don't know if Mr. Hay is in the room or not, but he will be made well aware of the circumstances of this case, and I guess we'll have the applicants pro hoc vice very soon. Is there any timing problem with that that we should advise counsel from Boston about? What sort of notice will he have to provide in order to be on the docket for, is it 21st of July? 21st of July would be I would ask that it be rescheduled, if it gets rescheduled to the 21st of July. Would ask that Campbell Hay, although not officially appointed the hearing examiner, at least get in touch with the parties and see what can be accomplished so we can maybe get a lot more done on July 21st than we ordinarily would when we open up a proposed docket. Is there anything else that
Mr. Chairman, this is Joe Houston. May I be heard briefly to press our position on the ability of the commission to approve an extension of the time?
You certainly may, Mr. Houston. With a name like that, and my name being Dallas, you have a lot of leeway.
As Mr. Blatt said, if we look at subsection F of the statute, it says that if no decision is made by the Public Service Commission within 90 days of the protest, then the matter shall be heard and determined by the Superior Court on application by either party filed within 120 days after the protest. If no party files an application, the Superior Court doesn't automatically pick this up and hear it. It requires an application, and as Mr. Blatt said, it is our view that until something that divests the Public Service Commission of jurisdiction is filed of record, whether it is an appeal from a decision with which one of the parties disagrees, or if one party doesn't get action within the 90 days mandated by the statute, that party can choose to file an application with the commission and file it with the Superior Court to divest the commission of jurisdiction and have the matter heard de novo by the Superior Court. I really think that with all due respect to my friend Ms. Donahue, that the reading that the staff has taken on this is very, very narrow and really doesn't reflect the whole point of this provision, which is to have these matters heard in the first instance by the Public Service Commission, and then only if there is an unexplained and unagreed to failure to decide the matter does it then get kicked to the Superior Court. Again, somebody has to file something in order to get it to the Superior Court. So it is our position that the PSC retains jurisdiction until some act divesting it of jurisdiction occurs.
I think that's a good argument. But I guess my point would be that I don't believe that you're going to lose that argument as of July 21st. You're going to still have the same position, correct?
Absolutely, but I'm just. This is something that you could take care of today, but our position would remain the same, and I don't think I'll speak. I think I can speak for Mr. Blatt, saying that as long as we can have our powder dry, that pushing this to the 21st so the Council for Chrysler can participate, I don't think that's a big issue.
Okay, right now the options are we reschedule it to July 21st, or we open up the case today, which I have no objection to myself, and just proceed. And then I assume that if we do the latter, which is open up the case and get Mr. Hay working, you all would then file subsequently some documents with us to be considered on July 21st in keeping with your comments today, correct? Or would it be better from a legal viewpoint to reschedule the entire thing and take action on the 21st? I guess I see as the two choices now.
Mr. Chair, based on what I've heard, I think I heard that one party does not have the authority to withdraw the filing, which means, as I interpret from the legal advisors, that the clock is continuing to tick.
Correct.
And so my view is that putting the order in place does not cut any optional, flexible avenue away from any of the parties. I would recommend that the Commission adopt the order, and if you're prepared to accept, I'll make a motion.
It's entirely up to you, Commissioner Gray. I think it's a good position. Go ahead and make your motion. We'll see what sort of thinking is around the table.
I move that the Commission adopt order number 8762 as submitted.
Second the motion.
We have some discussion, any discussion from the Commissioners with respect to the proposed motion to approve proposed order number 8762. Any Commissioners have any questions? Ms. Donahue.
Yeah, I just wanted to point out, I didn't want to point this out earlier until you made a decision, but there are some typos in the order that was sent to you. We have cleaned it up. The typos were primarily in the FCA US LLC. There was also a repetition in paragraph 5, which I've deleted from the clean order that will be presented to you. Mr. Hay will have the authority to grant interventions and also to do pro hoc vices, and that was in 2 different places in the order. So my apologies for not having that for you. But Donna does have a clean version with the typos fixed and with the duplicate paragraph taken out.
Mr. Blatt, any comments on that?
No.
Mr. Michaelak.
No comment.
Okay. Any questions? Mr. Houston? He's with Mr. Blatt.
No, Mr. Chairman, thank you.
Any Commissioners have any further questions or any questions? All those in favor of the motion to approve proposed order 8762 signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Gentlemen, we will see you here officially on July 21st. Thank you very much.
And Mr. Chairman, given the nature of that, do you want, would you prefer that we do this again by telephone, or would you prefer that we appear in person?
Well, I prefer to see you here face to face, if possible. I mean, I do understand naturally that one counsel is in Boston, and I believe that we customarily, when we have hearings or appearances, we have the attorneys appear here. How about Ms. Donahue? What is your observation on that request?
I think if there's going to be arguments, staff's preference is to have the parties here. It just makes the arguments flow better if people don't interrupt each other.
Yeah, and I was remiss in not thanking the Commission for allowing us to do this by telephone today. Until late in the day on Thursday, we assumed that this was just going to be more or less a formality where the pro hoc would be granted and an agreed upon order would be entered. And then the issue arose about the agreed upon order, so we were caught a little bit short.
No, that's no problem. And we try to be flexible, especially when someone is as far away as we have in this particular circumstance. But I can't think of any. Well, as of today, I guess we're expecting to see you face to face. Dover is a nice little city. I know where there's a board and breakfast place if you need a recommendation. And so we'll, unless obviously, I'm not foreclosing your communication with counsel with respect to that issue before July 21st. I mean, if things get ironed out and it's pretty much pro forma in terms of what you're going to do on the 21st, then I don't expect you all to travel here to see us in person. But if we are in fact going to have arguments about the issues, then I think it'd be best to see you in person.
Mr. Chairman, this is George Michalak. First of all, thank you for allowing me to speak today as a non-appearing lawyer. Secondly, in view of the fact that the hearing officer now has the authority to grant pro hoc vici motions, we'll present my application to him.
Yes, sir.
So that I'm clear on the 21st, what is going to be on the agenda?
Well, I guess that's a good question, because I assume any issues between you and the other side will be on the agenda. Anything that I guess Campbell Hay, as a hearing examiner, brings to our attention might be. So I guess we're going to notice this provision generally, and it'd be nice to know specifically in advance, but we're going to be flexible. Whatever you guys bring to us, we're going to handle.
Okay. And Mr. Chairman, Joe Houston again, and will hearing examiner Hay have the ability to address this issue of the parties' ability to agree to extend the 90-day statutory period?
Yes.
Will he have authority to issue a decision with regard to dismissal if necessary?
Yes. But it would obviously come to the commission.
Sure, I understand. What time will the hearing be on the 21st? 1 o'clock again?
Yes, sir.
Okay, thank you.
My pleasure. Is that all in the matter of the application of FCA US LLC? In that case, we'll go on to the hearing schedule, which is very slated today. There is none. Is there anyone here from the public that wishes to make comment to the Public Service Commission? Is our friend Mr. Noyes from DENREC here? Mr. Howard.
Chairman Winslow, commissioners, what a wonderful little sound system we've got going for us. I believe the technology will probably mature when I'm 110, and I will be happy to come back to the commission meeting at that point and see how well the new sound system technology and the live video streaming is working for us again.
Where are your hearing aid then?
I used it today. Under the administrative matters, I would like to talk a little bit about the financial security policy that I distributed to you. If you'll recall, on the June 2nd Commission meeting, we had rather lengthy discussion on security bonds and letters of credit. If memory serves me correctly, at that meeting, staff agreed to draft a policy for the handling of security instruments at the Commission office. I believe Commissioner Gray indicated it would be a good idea to get a bank relationship manager to talk through the issues. And Commissioner Correa asked that we share the policy back with the Commission. For purposes of discussion today, you have been given, hopefully, a copy of the draft policy. If you need a copy, I have extra ones. And it's designed to tell us how we will handle the financial security bonds and letters of credits here at the Public Service Commission. With respect to the bank relationship manager discussion, I personally reached out to my bank and was advised that security bonds and letters of credit should be treated the same way that you or I would handle commercial stock or bond certificates. You know, they're registered items. They have identifying features, and you would certainly keep them in a secure file, and you would maintain a separate record of those documents such that if anything happened, you at least had a reference to what the document was. So given that, we felt like we should just retain them in a secure file with a separate record identifying the specifics of each security that we had in the file. Now, the draft policy, I can highlight about a few of the things that happened in the draft policy. Number one, we will provide a safe, secure, fireproof storage for all active bonds and letters of credit. And I emphasize the word active because once they're released and gone, we will probably archive them as a matter of record, a copy, but we will not have them anymore in the secure file. But then again, the archiving is electronic, and so that obviously is as secure as the electronic system up there in the wonderful clouds will be. So we will have copies of it. Staff's responsibility will be to review the applications, to obtain the proper security, and to file them with the Secretary of the Commission, noting the index information requirements. The Secretary of the Commission will be charged with maintaining the file and the index of security instruments in a secure fashion and to archive those that are released or expired. The policy authorizes the Deputy Director or the Director to release security instruments as may be requested and when it's consistent with the current statute requirements. So it has to be a legitimate release based on current statute. The Director or Deputy Director is also given the authority to report and release missing documents as may be required. We're not exactly sure if we have all the documents in there. If somebody were to request a document that we can't find in our file, it would be my authority or the Deputy Director's authority to release and confirm the loss of the document to the issuing institution. Because there's general uniformity on how to transact these releases, but there may be differences from different issuing institutions. So we suggested in the policy that the release would be handled as requested by the issuing institution. And Commissioner Drexler pointed out in the June 2nd meeting that bank procedures are fairly standard, but we felt that we should follow the prescribed features that were provided by the issuing institution. So we will make sure that we adhere to the issuing institution's direction in releasing any bonds or letters of credit. And lastly, we would ask that the Secretary of the Commission do an annual audit of the file to maintain all the required securities and to ensure consistency with current indexes. And with that lengthy summary of where we are on this policy, I will defer to the Commission's consideration of any changes they may want to make.
Thank you very much, Mr. Howard. I read the document, and I think earlier I commented to you that I was proud of you because it was just 2 pages, if I recall correctly.
Yeah.
And then I went to the agenda here, and I got down to your comments, and I can't click to open up my document. So I guess if I could go. Okay, thanks. Okay, I don't have any questions. But any commissioners have any questions? I think that Commissioner Correa?
I have an idea that if the commission secretary is going to maintain the files, I believe that the audit should be done by someone else and not by the secretary. So audit should be a third party, like for example, deputy director can do the audit, because the person is maintaining the files and also doing the audit. It's like same thing. So we would have someone else at the commission or in your office, just audit the file at the end of the day.
Is that a motion you'd like to put on the floor?
Yes, sir. I would
That's
like-
so, is there a second to that motion?
I'll second that.
Is there any discussion? Commissioner Drexler? No?
I like it.
Okay, all those in favor of that motion signify by saying aye.
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 Any opposed? Any abstentions? Motion passes unanimously. I think it's an excellent recommendation. Thank you, Commissioner Correa.
I think everybody should have this policy, everybody who holds letters of credit. The policy.
Are there any other suggested changes to the policy by the commissioners? I don't believe this matter needs a blessing, so to speak. It's a policy matter by the staff, and I would like to thank them for a job well done, and I believe you'll consider the change correct, Mr. Howard?
I will, sir.
And thank you so much.
The last comment that I have under director's comments is that our next meeting is July 21st, here in wonderful downtown Dover, starting at 1 o'clock.
Is there anything further from any parties here present? Hearing none, we are adjourned. Thank you all very much.